So our first talk this morning is a case law update presented by Cole Ruiz and Lauren Ice. Cole is a principal at Lloyd Gosling, and Lauren is a partner at Paralis, Almond, and Ice PC. Cole frequently represents districts, while Lauren often represents protestants, giving us a perspective from both sides of the courtroom. We've asked them to share the latest updates in case law from their unique vantage points. Please join me in welcoming Cole and Lauren. Okay, here's the clicker.
Okay. Do you want to be up here when you're speaking?
Yeah, y'all can just.
Yeah, you can stand up here and I'll sit and then we can switch.
Okay.
It'll be easier for me with my computer.
Sounds good. Good morning, everyone. Thank you for that introduction. Again, my name is Cole Ruiz. I'm at the law firm of Lloyd Gosling, Rochelle and Townsend. As was said, I represent a handful of groundwater conservation districts throughout the state. My firm serves a lot of those entities, and so I will be kind of providing that perspective. Although I'll also say that our firm has a lot of experience representing both sides of these issues, and so I'm eager to hear any questions you have from any of those perspectives. I will say before we get started, we were asked to address some specific cases for this update, and so I'm going to focus on those. If there are questions about others, we'll try our best to handle those in stride. Okay, so the first case I was asked to kind of address was the Sanderson Farms versus the Neches in Trinity Valley Groundwater Conservation District. This one you've probably heard a lot about just from being alive in Texas. It's been in the news quite a bit. There's a collection of landowners, and they happen to be poultry farmers in this part of the state, and they have sued the Neches Trinity GCD to try to prevent or at least slow down some permitting decisions that district is considering and taking on. This all sort of happened in light of a number of other lawsuits and litigation that's going on throughout the state, contemplating large groundwater production permits and export permits. And so I'm going to talk about this case a little bit. I will say it's not fully developed. There's been some pleadings filed, but there's not been to my understanding, there's not been any rulings on the merits. And so I'll talk a little bit about what the claims are, and then also follow up with some of the events that this particular case has triggered, specifically during the special session, the first special session, and then I'll talk about one bill that was actually filed yesterday that seems to be flowing from the same pattern of facts. The case is based off of, or it's directed towards an application to produce a significant enough, well, I'll say the application is actually just for drilling permits, and the action that the board took was to deem that application administratively complete. There's not been any action, to my knowledge, to approve those permits yet to drill the wells, and certainly no consideration of any permits to produce groundwater. But as far as the lawsuit what the claims in the lawsuit contain, is that some allegations that the applicant, Red Town Ranches, is seeking to drill 43 water wells that would produce upwards of 49,000 acre-feet annually out of the Carrizo Wilcox, and seek to export that water ultimately outside of the district to serve some communities that that need that water. The relief that was requested by the claimants, the petitioners, is a judicial declaration that the actions on the drilling permits by the board are invalid. That action, again, being deeming those applications administratively complete. And I'll take a step back. A lot of the districts in this room would consider deeming an application administratively complete as an administrative function, not necessarily an action that requires board approval. So those are issues that I think will come up as this case carries forward. But that is, right now I'm just talking about the claims in the lawsuit. It also seeks temporary injunction to enjoin Neches Valley GCD and SOA from engaging in any further activity concerning the drilling permit applications, including any action in response to the district's votes on the drilling permit application. Again, it's going back to that vote to deem it administratively complete. And then it requests a writ of mandamus to stop and reverse the alleged violations. So immediately after this came to light, it raised some eyebrows at the legislature. For context, this district is in Chairman Harris's, the chairman of the House Natural Resources Committee, legislative district. And so it struck a chord, I think, with the locals, and several bills emerged immediately after a hearing some of these concerns out of that district. Really focused on protecting local groundwater from export. The bills collectively, I think, would have some far-reaching implications. And I know a lot of the districts in this, present here today, have probably looked over that language, and it might have caused some shock and awe. I think ultimately the purpose of a lot of these bills was to start the conversation about whether the legislature needs to take a serious look at how we manage groundwater in the state and make changes to that. Yesterday, a bill was filed that's a little bit more subtle, more directed, more targeted at the Neches Trinity Valley GCD, and that would amend their enabling statute and require the Water Development Board to assess annual recharge inflows, discharges, spring flows, and interaction between groundwater and surface water from transfers of groundwater out of the aquifer underlying the district. So it's really looking at trying to assess and gather better science and data on that district so that it can make better decisions. And then in the meantime, it would place a temporary moratorium on new permit or permit amendments to export applications. Again, that's a bill that was filed. To my knowledge, there's nothing on the governor's order that would consider this, and so until that happens, it's really probably not going to go anywhere. But that we'll see what happens there. Real quick, I also want to mention there is a typo on this. House Bill 2016. The note says block new well permits. It's really about blocking export permits. So that's just a typo. The other case that I was asked to sort of address and spend some time with is the BLF land case. This case was filed against the North Plains Groundwater Conservation District in federal court, seeking, at its crux, it's a takings case. And so I'm going to go through the facts and history of this case. It has been resolved as far as I know, and so it also kind of follows up. If you were here for yesterday's discussion with the Chief Justice and his references to the Day case, this case contemplates some of the same topics, particularly the factors in Penn Central that were referenced yesterday, being the seminal regulatory takings case in federal court. Here, the petitioners are the BLF Land LLC. They are potato farmers, and the defendants here are is the North Plains GCD. Real quick, the factual background. BLF. Well, let me start by kind of just talking about the district's rules as I understand them. I don't work for the district. I was trying to kind of speed read their rules this morning to kind of understand and get a better grasp on them. Essentially, as I understand it, the district has some rules that create what are called groundwater production units, and these units are basically an area of land that is defined by the rules that, from what I can tell, the purpose of this rule is to create some dispersion of the wells to minimize impacts on groundwater drawdown. And so those rules were adopted under the authority of Chapter 36, which allows districts to adopt rules and to enforce rules to minimize as far as practicable the impacts of groundwater drawdown and all of the impacts that come with that, including degradation of groundwater quality. So the sort of the injury that is being claimed here by BLF is that they had overpumped their permit and not in compliance with the district's rules. That led to a series of violations and notices of violations. It led to a series of fines authorized by the district and or civil penalties, as they're called, and ultimately there was a process whereby the BLF could request a variance to that rule. That variance was denied after a hearing and notice, and through some negotiations, the North Plains GCD agreed to enforce a fine of $500,000, which is quite less than what was invoiced initially at around $1.8 million. And BLF, of course, turned around and filed their lawsuit. The theory on which BLF relied to attain standing in federal court was under federal law, under the Equal Protection Clause, asserting that they were a definable class because they are under the rules, the GCD's rules, considered large landowners. Of course, this is not a suspect class that's recognized in federal law, and the court addressed that. They also claimed differential treatment that was not rooted in any sort of rational basis, and the court would ultimately address that as well in summary judgment. They also claimed there was a lack of due process, and that the district's actions were arbitrary and irrationally infringed on their rights. And then there were multiple takings claims. One was the per se takings, and the other was regulatory takings. And I'll address both of those in the next slide. So this case was there was a cross summary judgment, or claims for summary judgment filed. The court ultimately disposed of all of the claims except for one in its initial ruling. The first was that there was no takings, that no takings occurred, finding that BLF still had access to their property, and so one of the requirements for a per se takings is that it's taken or the property is invaded such that there's such an impact that there's some sort of compensation due, and the court found that as a matter of law did not occur. And as far as the regulatory takings goes, they ran through the Penn Central analysis and found that the economic impact to BLF was not sufficient to warrant a regulatory takings. Since from their estimation, at worst, the plaintiff their plaintiff's land would only be devalued by about 9%. In reference to other cases where it would exceed, I think 42% is the number that they referenced in the case. So the economic impact was minimal. As far as investment-backed expectations go, the rules that were in place and were enforced were also in place whenever BLF had originally purchased the land, and so the court found that there was no basis for an investment-backed expectation when they bought the land. And then the question of government action and whether it was the government action exceeded the district's authority. Essentially, the court said, no, this is something that is contemplated by Chapter 36 of the Water Code, and districts have the authority to regulate groundwater, to minimize, as far as practicable, the drawdown, reduction of artesian pressure, interference between wells, and the degradation of water quality. So this justification by the statute was sufficient to justify the government action that was taken. And then with respect, there was a series of orders that came out on different motions. Ultimately, the court dismissed the due process claim as well, and the equal protection claims, really referencing back to that takings analysis. And then the one case, or the one claim that was undisposed in the initial ruling, the court ultimately, again, disposed of on a summary judgment. This was the ultravirus claim that BLF had claimed that the district acted outside of statutory authority. Ultimately, this came down to an analysis of this groundwater protection unit rule and whether that was an ultravirus rule. And the court looked at the water code and said, no, this rule is sufficient to justify, it's sufficiently authorized by Chapter 36. It references 36.116A, and specifically those rules, that language as far as practicable. In other words, BLF was claiming that there's no way that these rules could sufficiently achieve Chapter 36 true intent. But the court looked at that as far as practical language to indicate and to demonstrate to the plaintiff that actually the district has carried out its responsibility with respect to Chapter 36.116A. There was a counterclaim that was also not disposed of initially, and that was seeking the court's jurisdiction and authority to enforce the district's civil penalties. The court ultimately said, this isn't a federal question. We no longer have a federal case, and so they decided to not exercise jurisdiction over that claim, and ultimately disposed of the case. So I'm going to pass it on now.
I did not prepare slides, so I'm going to read off of my computer, but hopefully it's just as entertaining and informative as Cole's presentation. And I would also just like to reiterate, we don't have a lot of time, so we'll be available after this and at lunch if folks have more questions about these cases or about other cases that we've been working on. So yeah, my name's Lauren Ice. I'm an attorney with Perales, Ullman, and Ice, and we primarily represent protestants in groundwater matters. And the one case I was asked to talk about, and I think that I have time to talk about today, is a case, and so it's from my perspective representing protestants, not from the district, of course, but it's with the Bandera County River Authority and Groundwater District, and the case that was the application that was filed by Vanderpool Management for 200 acre-feet of groundwater from the Middle Trinity there, and just how that case went. That was an application for 2 wells. Actually, it was split between 2 wells. It was filed in 2023, when it went to and I see the general manager of the district sitting in the back of the room there. When it went to the general manager, he recommended, based on the application that was submitted, that the district just grant 28 acre-feet per well, so 56 acre-feet total for the applicant. And from the protestants' perspective, that was already a pretty generous recommendation based on the application that was filed, just because that application was so deficient. There were a lot of contested issues. So after the board voted to grant just the 56 acre-feet, of course, the applicant filed a request for a contested case hearing. Our clients also requested a hearing to intervene to participate as parties because they were concerned that the applicant would want to get the 200 acre-feet. And so we did go to a contested case hearing, and our clients, was a conservation group in the area, participated as parties. And as I said, there were a lot of contested issues, mainly just because the application that was submitted was so deficient and problematic. And one of the lessons learned, I think, through that case was how challenging it was to deal with an application that was changing. The expert who prepared the application actually ultimately wasn't even the expert who testified on behalf of the request during the hearing. And so our clients, as well as the experts for the general manager, were left kind of dealing with an ever-changing application. It was changing day to day, even during the contested case hearing process. So, one of the things we really took away from that process was the fact that if there is not a date by which an application has to be considered final and unamendable during the process, we could be going through a contested case hearing where we're being asked to offer testimony and review, evidence in the record, but that's changing day to day. And in this case, it was literally changing at the hearing on the merits on the stand. So we are trying to adopt some things and make some recommendations to our clients that would help avoid that happening in the future, because it was just so challenging. But given that the application, it is the burden of proof is on the applicant to show that their application meets the requirements that are in Chapter 36 of the Water Code, that meets the requirements of the district's rules. Our clients argued that the district shouldn't grant them any water if we're applying a strictly legal standard, that they didn't meet their burden of proof because they didn't have an application that could demonstrate that. As I said, there were a lot of issues that were contested, but I think what the big three were that ended up being the big three issues at the end of the day were whether the proposed use of water was going to unreasonably affect the groundwater resources or the existing permit holders, whether the proposed use of the water was actually dedicated to a beneficial use, and whether the proposed water was consistent with the district's management plans. And I'll say that the position that we took, again, being the position of the protestants who were concerned that this was a lot of water for one particular applicant that was going to have impacts on neighboring wells and neighboring properties' ability to pump their groundwater in the future. The position we took is that the district had an obligation, not just the authority, but the obligation to rely on best available science in order to predict drawdowns. And so there was a lot of competing testimony in this case. But at the end of the day, our position was that the testimony of our expert and the testimony of the general manager's expert was based on best available science, and that the applicant's wasn't, and so the applicant's testimony wasn't reliable. The other position we took is that the district had not just the authority, but the obligation to consider the use of the water, both the location and the type of use, because in this case there was a lot of testimony about whether or not that was something that the district could ask the applicant to demonstrate. And if there is a requirement in Chapter 36 that the proposed use of water be dedicated to a beneficial use, we took the position that in order to ensure it was going to be put to a beneficial use, then the district had the authority and the obligation to ask what that use would be. And so, of course, the applicant argued against that, but at the end of the day, that testimony did come into evidence. And then finally, the other big issue that we argued for was the fact that the district's management plan included a very clear provision that said that in determining whether to grant permits or to deny permits, that they had to consider the equitable distribution of groundwater in their district. And given that this was an application that represented such a large amount of water relative to other users in the district, we argued that that was relevant evidence that not only that the district had the authority to consider, but the obligation to consider for the benefit of other landowners and groundwater users in the district. So we ended up getting a proposal for decision from we had 2 administrative law judges in that contested case hearing, a proposal for decision which really, in my opinion, put the burden of proof back on the protestants to show that there definitely was going to be this unreasonable impact and that they were definitely not going to be able to put their water to a beneficial use. We felt like that was an improper flipping of the burden of proof. And fortunately, the district, the board of directors in the district agreed with us. And so in February of 2025, earlier this year, they voted to grant the application, but to limit the permits to 28 acre feet apiece. So they gave the applicant 56 acre feet total, far short of the 200 acre feet they were asking for. And so, of course, the applicant appealed, and that appeal is currently pending in district court. In the appeal, the applicant has argued that the district made 5 errors, and we don't have any development on this. The case is still very early in the appeal, but I just thought it might be useful to point out what those errors were in case folks were wanting to watch this and see how it unfolded. But basically that the board failed to meet the requirements that the changes from the findings of fact and conclusions of law that were in the administrative law judge's proposal for decision, that they failed to explain their changes with enough specificity, although they did issue quite a lengthy explanation when they did issue the order. The other error that they've alleged is that the district considered evidence outside of the hearing record, even though the board made the statement that they didn't consider any evidence outside of the hearing record. They also alleged that there was a violation of the Open Meetings Act because the board made deliberations in executive session without then coming out into public session and deliberating in open session and explaining their reasoning there, even though they did explain their reason in their written order. They've also alleged that just sort of a general objection to the fact that the board considered the beneficial use of the water that the applicant proposed, how they proposed to use it. And also, kind of strangely, they've objected to the district asking for additional briefing after exceptions. So once the proposal for decision was issued, we had an opportunity to file exceptions explaining why we disagreed with the proposal for decision. The board then, being the ultimate decision maker, asked the parties to file additional argument, essentially relying on the same evidence, but just additional argument to answer a few questions they had. We did that, and the applicant in this case is saying that that's a point of error. So I obviously disagree with all of those, but that's kind of forecasting what may be the issues in this case. And this is a district where I think, again, from my perspective representing the protestants, a district where there is a lot of increased sudden development pressure. So this was one of the first contested case hearings we've seen go through a full-blown hearing on the merits with this much evidence, this much testimony, and so there was a lot to be learned, I think, in this case, and I'm happy to talk to anybody about that more if you like, but I was very pleased with the decision that the Groundwater District made at the end. So I think we're pretty close to time, so I'll go ahead and wrap up there. Thank you.